And the first issue in the financial services area is the fiduciary standard, the so-called fiduciary rule. Now, the particular law that we are considering today is not the 2018 law that was, or bill that was introduced, but the 2019 bill that was introduced. So what we'd like to know, Commissioner, from you is looking at all these regulatory parts, what you feel your interest is, your jurisdiction is, what the NAIC may be doing, and how you plan to address this, if at all.
Well, thank you. Like, it's not like that's like a little topic. So, and it is a significant topic, and it's a serious topic. And I'll sort of preface my remarks by just saying that I kind of prefer scalpels to meat cleavers. And, I feel like, part of this discussion is really around trying to take a, very gross one-size-fits-all approach to what is really a much more nuanced and very circumstance-specific set of considerations. So, our position was that the article already afforded the commissioner, comprehensive authority to protect consumers, and it does so. And we really don't need a second layer of oversight over that. And I share that perspective. And, I would expect if that bill were to return to take that same position again. I don't think that, it's necessary. I think the MIA has authority and it does its job well, and frankly, in a more nuanced and fact-specific way that takes more into consideration the actual relationships that exist and that form, as opposed to a one-size-fits-all, pretty draconian approach to every single interaction or every single relationship interaction, and to Joan's point, what do consumers actually want and what do they really want to, pay for? I can tell you that I did not track or follow what happened in 2019 in Maryland. I know that the MIA testified against the 2019 fiduciary standard bill. And that, the reasoning for that was because, the MIA felt, among other things, that it was simply redundant, that it really wasn't necessary to add insurance producers to AG oversight since, essentially a key purpose of the MIA is to oversee producers. And frankly, I think the MIA does it pretty well. So, our position was that the article already afforded the commissioner, comprehensive authority to protect consumers, and it does so. And we really don't need a second layer of oversight over that. And I share that perspective. And, I would expect if that bill were to return to take that same position again. Look, the bottom line is that we expect our professionals and our licensees to comply with the law and with their obligations to their client. And from my perspective, and I guess this is part of my legal background, I think the common law provides us with a workable framework of what those standards of care are. When is someone actually a fiduciary and what does that mean? Is there a place and a time potentially where, some of that can be captured in, a more consistent manner so that it's not completely reliant on the evolution of case law? Maybe. But is that what we've seen come out of some of these legislative proposals? I don't think so. And again, it just gets back to me that idea of we have to care about context. We have to care about consumer expectations. We have to care about what's proportional and what makes sense. And, you can't just come at things with a meat cleaver. You need a scalpel. So I hope that gives you a sense of, my approach.